Hello, everyone, and welcome to today's VUTV episode on careers in ADR, arbitration, mediation, and the future of ODR. As the legal landscape transforms, ADR is becoming one of the most dynamic and in demand field for young lawyers. So, to help us understand this fast evolving space, we have here with us Ms. Aditi Pawar, an international legal strategist with global experience in arbitration, mediation, and cross border disputes. Welcome, Aditi. It's wonderful to have you here.
Thank you so much, Pallavi. It's such an honor to be here. Thank you.
So, Aditi, let's begin with the basics.
Hmm.
Many students here still hear the term ADR without fully, understanding it. How
Hmm.
would you define ADR for someone who is completely new for the concept?
Ah, so let's go down to the basic of it, all right? ADR, that's your alternative dispute resolution. That's it. If you know the imperative word here, the imperative word here is alternative. You have your court litigation. Everything that is not court litigation is your alternate dispute resolution. It's as simple as that. And of course, the bracket of the ADR system in our country, or rather all over the world, is very wide. You have arbitration, you have mediation, you have negotiation, you have conciliation, you have online dispute resolution. So of course, these are various branches of alternative dispute resolutions. They overlap at times, but as you progress studying about it, you'll understand the finer nuances of it. But just the basic of it is whatever is not in court, and if you're going to try resolving an issue outside court, it's going to be alternative dispute resolution.
I hope everybody is able to make it. Now, coming to the question of what kind of disputes, like there are different kinds of disputes, and I'm sure every dispute is not fit for alternative dispute resolution. So, can you please tell what disputes are best suited for mechanisms like mediation, arbitration, or ODR in the sense?
Okay. Uh, so let's begin with something like arbitration because that's a word that is used far too often, right? Now, your arbitration is per se, as I said, is a court outside court. It's as simple as that. But of course, we don't use the very strict evidence rules and code of civil procedure rules, right? It's different. The procedures are a lot more easy. The procedures are agreed by parties. The arbitrators are agreed by parties. But again, and most importantly, the awards are enforceable, right? My terminology might be a little difficult right now, but it's very important for me to use these terms because the more students listen to these terms, when they're reading it, they will understand what I am saying. So when we are talking about arbitration, your commercial contracts, be it a share purchase agreement or be it share disputes, a shareholders agreement, a real estate contract. These are your heavy duty commercial contracts that, or more often than not, go to your arbitration, right? Uh, Coming to mediation. Now, mediation is something, understand from which perspective we are going to mediation, right? We are primarily going for a mediation to resolve an issue. So if we are going to resolve an issue, what are the issues? Most often, these are going to be issues that are a lot less on merits, a lot more on ego. Practically, the more you get into it, when most of the students listening here and when they'll become prolific arbitrators in their time, they will agree with me. Your family disputes or your partnership disputes or your co-founder issues when startups start, these are when these issues rile up. These are issues that need to be sorted with practical solutions. So you have your mediation, and your online disputes are your credit card issues, your consumer complaints, your e-commerce disputes. These are issues that require fast resolution and are high in volume. So this is the demarcation that we ideally have in our head when we are going towards an ADR perspective.
So, Aditi, speaking of in particularly arbitration, we have seen it is quite dominating in the case of commercial disputes.
Yes.
It is a preferable mode of dispute resolution in case of commercial disputes.
Yes.
Can you tell us why people prefer or commercial companies prefer arbitration as a mode of dispute resolution?
Okay. One of the main reasons, and I'm talking about the big guns, okay? When the big guns want their disputes to be handled, their biggest issue is confidentiality. and they do not want their uh, disputes, or they do not want their goodwill to be affected. That
Yes.
is one of the biggest concerns as to why we have companies or even private clients coming to arbitration, because of confidentiality, because of flexibility. There's a lot of flexibility in arbitration. As I said, you get to choose your arbitrators, you get to choose, the procedures that you can follow. And most importantly, I'll tell you what happens is when an award is passed, right? An award can be enforced in a lot of countries. So you have that flexibility. Because of that, this is a far more preferred mode of dispute resolution that I see companies, or as I see private clients taking. More often than not, it's, as I say, it's literally for a confidentiality issue that I have always, every time I draft a dispute resolution clause, and if I'm sitting with my clients, the first concern is always this, that Aditi, if there's a dispute, we don't want it in the paper.
Yeah.
So, and
So,
I think it's just commercially a lot more viable now.
yeah. Yeah, true. So now there are, I believe there are different kinds of arbitration, it seems. So if domestic arbitration we consider and international arbitration, how would you differentiate between domestic arbitration and international commercial arbitration?
Okay. Difference, very same, very similar. Sorry. Going back to the terminology, domestic, international. Let's look at domestic. Your domestic is what? Your domestic is going to be the contract that is going to be governed by Indian law. You're going to have both the parties as Indian parties.
Yes.
That is your basic there. When it comes to international commercial arbitration, one party has to be a foreign party, for sure. The contract, can it still be governed by Indian law? Yes, but it still has an international. Sometimes it's governed by English law. Sometimes it's governed. I mean, I have done a agree international commercial arbitration where Albanian law was involved. So. So of course you have various laws that can be used. You have international set of procedures. You have institutional arbitrations that give their rules, and we have to follow their rules. So the basic is, what are the parties? Who are the parties? And what kind of law is going to be followed by the contract. So this
Yes.
is your basic with international and domestic arbitration. And one primary factor that I see in domestic and international arbitration is, and this is a practical one, domestic arbitration still, unfortunately, in our country, use a lot of pleading style that is used in court, which is not to be done. In international commercial arbitrations, the pleadings are shorter, the arbitrations are faster, because you necessarily don't need a physical hearing every time in an international commercial arbitration. The arbitrators over there will probably ask you, do you need one? So they're a lot faster. You finish off arbitrations on the international side a lot faster, say within 6 months.
Yeah.
Here they take a lot of time, but both of them have their advantages and disadvantages, but this is the primary difference. So anybody who's doing domestic and international arbitrations have to change their way of thinking and change their mode of working on case to case basis.
I'm sure you must have to do it on a regular basis then.
When I started out, it was very difficult because we are
Yeah.
used to writing very lengthy paragraphs. uh,
Yeah.
but once or twice when you get reprimanded by English arbitrators,
That's true. Okay. Okay. Moving on, Aditi. This is all about arbitration. Let's dive into mediation now. So we know there has been a new act that came up, Mediation Act 2023, and it has been a landmark reform. Can
yes.
you tell us why it is considered as a landmark reform in the area of ADR?
Because for the first time, something has been given a structure. For the first time, something is pushed to believe that your dispute is here to be resolved amicably,
Yeah.
without filing court proceedings, without filing those pleadings in front of the arbitrator. So there is a lot of credibility, there is a lot of structure. And I felt that when that act came in, that act on its own encouraged a lot of people to actually consider resolving disputes vis-a-vis to fighting a dispute. This is a big difference. Everybody started with now there's a set, there's a mindset change that, oh, with the mediation act we can. Why? resolve an issue. Why? Because the settlement agreement can be enforced now. The
Yeah.
settlement order can be enforced now. So I felt that Mediation Act has come in at such a right time in our country.
But there is still, I mean, more awareness to be spread across people because even after Mediation Act came into force, there have been cases which have gone for litigation instead. They should have opted for mediation. Maybe they were not aware of the act or the statutory importance of the act. That's why. Do you feel there is a case that should have gone for mediation instead of litigation after the act came into force?
After that coming into force, so there are too many, but I'll tell you what, after the act came into existence, it's the lawyer's duty to
Yeah,
deliver.
of course, definitely.
Client is coming to you because he wants advice. So as a lawyer, your primary duty is to ask your client, what do you want out of this? Do you want this to fight? Do you want to do this for your ego? Do you want to do this to, secure,
Settle the
yeah,
yes.
or do you want to settle the dispute? Once you're clear on that, it's your absolute duty as a lawyer to direct your client at the right place. If it's a family dispute, I would always recommend clients to, try the Mediation Act and all of that. See, I don't particularly remember if this case was 20. No, I don't think this was 2020 after 2023. But one of the main cases that I really think should actually have gone into mediation was this very particular case between, Infosys and I think their CEO, Mr. Sikka. There was a dispute about governance issues, and I think there were pay package issues and all of that, and it had riled up the newspapers that time. I think it was 2016-17, if I'm not mistaken. But what I saw was that because Infosys is such a credible name in the market,
Yeah,
and when such issues have go up in newspapers and they're flashed over television, right? The morale of the people, or your workers or your employees working there, goes down.
yeah,
I,
true.
I genuinely feel that was one issue that could be resolved through mediation if that act would have come in place then. Or even if not, I think mediation, even if we did not require an act that time, uh, it could still have gone through mediation or negotiation. Because
Yeah.
because these were governance issues that could be dealt with. These were not monetary considerations.
Thank you for your insights, Aditi. Now, if we come to the next part, that is ODR, that is a fresh new concept for the world, online dispute resolution.
Hmm.
How do you think it differs from traditional arbitration or mediation?
See, the basic idea is same because it's a dispute resolution,
Dispute
right?
resolution, right? Of course.
How is it going to be different is on the premise that it's going to be more technologically driven. That's your biggest differentiating factor. Also, it's a lot faster, it's a lot cheaper. Plus, you are not dealing with heavy duty commercial contracts there. You're dealing with issues that require fast resolution.
Yeah,
As I said, consumer complaints, your credit card complaints, your banking complaints that probably go to a city civil court or some other court where they've been there for 20-25 years. So that is the only difference that I see when it comes to ODR. Do I agree with ODR? Of course I do, because now there is a separate system to deal with, this strata or work. That would take up the court's time, or that would take up, say, for example, the arbitration's time. So your tech is what is driving ODR.
driving,
It is
yes, of
about time it
course.
does.
So, for the students that are there, do you know about any ODR platforms that are currently operative in India, and how students can contribute towards it? Is there any way that they can contribute towards it?
See, I've not used any. I'll be very honest with you. So, to take my word for it and go, I mean, I'm going to put that caveat in. But I do see this ad, on LinkedIn. I think it's Presolve 360.
Resolve
Yeah.
360,
So
yes.
I've seen that ad. So I'm assuming, it's a good one that, because they have hired a great marketing team, I believe. So I think, students can definitely try there. And see, you know what? No experience is going to be a bad experience. So, what I would suggest is, I'm sure there would be some, maybe there's something called a Just Act. Have a look at it. Um,
Just.
Yeah. So what students can do is apply for internships there. Uh, Try being case managers. You know, when you're a case manager, you actually learn a lot because you're getting a bird's eye view of everything. You're also, you're sitting there as a manager to, to probably just collate papers.
Yeah.
But that collating of papers can teach you a lot because as an intern, the first thing you should know is how to understand a brief. So, apply there for as a case manager, apply as a researcher, apply if if they have online, neutral parties resolving these disputes, see if you can assist them in all of that. So, and the fact is that today we are being so tech driven as a country. We are also using tech in our dispute resolutions. I think these internships can actually help them to be very tech savvy, which
Yes.
is very important, very, very important.
So, Aditi, since ODR is heavily reliant on tech and everything, and we know that there is no dedicated ODR statute
Yeah.
which is existing as of now.
Yes.
So, do you think there might be any legal challenges or issues that might arise due to the technical exchange of information?
100%. 100%. I mean, this is such a brilliant question, and this is a question that always arises. Two things. Two things which are very important. One is your enforceability.
Yeah.
Once I have the order in my hand, you call it an order, you call it an award, you call it any terminology that is being given by an online dispute resolution. What is the validity and where do I enforce it? And even it's an award, right? I can come for an enforcement, say, for example, an enforcement of a foreign award under Section 44 of the Arbitration Act. I can still come to, I can come here and I can enforce it. I can enforce a foreign order
Hmm.
under
Of
CPC
course.
here. I have to convert it under the Indian order and I can still enforce it and then execute it. How do I execute? How do I enforce this? This is a big gray area. The second one is jurisdiction. If I have to challenge a particular award slash order on a jurisdiction, what is the jurisdiction of an online dispute
How
resolution?
will I decide? Yes.
What do I call as a jurisdiction? So these are two things that have always worried me a little when it comes to ODR. But then again, as I say, you know the monetary consideration of matters that go to ODR is so small that sometimes these issues don't arise. But these two things definitely are something which are a burning issue and will be a burning issue as in how ODR improves, ODR increases, because I know for the love of God it's going to increase. Also, confidentiality and data privacy. Absolutely, that is something uh, that I don't. That is something that I think our country is also working on towards that. Not all the laws of we are.
Although there is a provision included in Mediation Act about online mediation, but there is no separate legal statute
There
yet.
isn't. There isn't. Because see, at the end of the day, our data privacy laws, our confidentiality laws, or just in general, even a confidentiality clause in an agreement, more often than not, is just any other clause.
Yes.
So these, again, these two considerations are a burning issue when it comes to
Yeah.
ODR. And I think we have a long way to go. Will we reach there eventually? Yes, but we have a lot of work to do on that.
Yeah, I'm hoping we get there and sort this.
We
We
will.
don't have to sit for physical meetings and
I'm an
hearings every
eternal
time.
optimist, so
Yeah,
we will. I've been in the profession far too long to know that negativity doesn't work out.
sure. So, Aditi, since this is a podcast catering for students,
Hmm.
so we would like to know what if a student wants to start a career in ADR today,
Hmm.
what would be the first step they should take, and what should not be their first step, what they should avoid, and what they should take.
Your first step, if you want to do anything in ADR, learn litigation. Because the minute you know litigation, you will know what exactly not to do in an alternative dispute resolution. If anybody who wants to come into ADR practice, if they do not have a litigation background, they are going to be lost at sea. And I'm not here to discourage anybody from coming on the ADR side. It's a beautiful side. It's something that I'm very passionate about. But I had the good fortune of being into heavy dispute practice for a very long time in my life when I decided to streamline my practice into ADR. If so, one thing that I want students to understand is that in your first year or in your second year, please don't start with ADR. Start with court. Your court is where you're going to be taught the procedure. Because when you're at an ADR internship, when, say, for example, with an arbitrator or with probably a counsel who's only doing arbitrations, you will understand very clearly as to why a particular arbitrator or why a particular counsel is not using this procedure, because he can say, oh, you know what, this procedure works in court. Can I be flexible and not use it here? Yes. But to make that difference, it is very important to understand what goes on in court and what I should not bring to, in a boardroom where arbitrations are held. It's very, very important to know that. What students should not do, don't aim to be an arbitrator at the first go.
Of course.
If is that your aim, lovely.
Yeah.
But if you're going to go with that headset that I only want to be an arbitrator and I'm only going to do internships with an arbitrator, I feel so that there is a lot of learning to do, which gets shrunk if you just start with an arbitrator. Start with litigation, start with a litigating law firm or with a litigating counsel or whatever it is, understand the court procedures, then go into arbitrations. Because when you are being told to draft pleadings, you will understand how pleadings are drafted in court and in arbitration. Then once you've done with arbitration with the counsel who is doing exclusive arbitrations, then move on to interning with an arbitrator.
True.
Go stepwise. Don't go reverse, because that's something where where the learning is not where the learning will not happen. Like, I have these things every time I get an internship application. My first question is this: have you done litigation? If you've not done litigation, I will keep a place for you. Do 2 internships in litigation and come back, and I will have you back in my chambers. I don't have a problem.
True. So, Aditi, we know colleges in India are very much aware about litigation. They encourage students for going into litigation internships and everything. But arbitration is something that is not so much talked about in the school or colleges that offer law courses.
Hmm.
So, are there any specific law courses which students should take up in their academic journey, or you think universities should offer more to the students that are aspiring for arbitration?
See, first thing, students, before taking up any courses, should make sure that their foundation with the Arbitration Act is absolutely perfect. If you want a career in ADR, your hold on the Arbitration Act should be there. That your Bare Act is your everything. Your Bare Act is where you command your knowledge from. So first start with that. Then understand how the other commercial laws come into place, which is even your simple contract act, then your procedural law, CPC, then your evidence act. These are your foundations. So before doing any other courses, make sure that your foundations on these are correct. And then, of course, there are a lot of international courses that are happening, but I just feel that, go again, stepwise. And courses that I really think colleges should introduce now, India is reaching at a market where we are promoting ourselves as the next big international arbitration hub, right? Contract drafting, not taught at all. And second, cross-border contract drafting. I don't think
Yeah.
anybody,
No.
nobody takes that, because your cross-border contract drafting is something very different.
Yeah.
Um,
Something very different from normal contract drafting.
One thing which is very, very close to my heart is advocacy in arbitration. It's different. It's absolutely different. when I say it is different, because I believe that arbitration is a faster resolution method. That is the reason why when I am arguing in an arbitration, I will make sure that the way I argue in court vis-a-vis to the way I'll argue in an arbitration, whether it is domestic or international, my skill set, my timing, my number of submissions all reduce. So understanding advocacy, or understanding procedural, understanding how arbitration works, I don't think any college teaches that. And the other one, negotiation.
True.
I remember during my time, I don't know if it's still there, there's some concept called as client counseling. I'm sorry, but I used to find it absolutely ridiculous. I used to find it absolutely ridiculous at times, with that client counseling bit.
I don't think we have it
Yeah,
right now.
I used to have it in my college, and believe me, I used to hate it. I mean, I still find it absolutely ridiculous, this client counseling bit.
Yeah.
But do I expect colleges to have something called as a commercial negotiation workshop? Get part, get the get your students to, give them a matter to say that, okay, how are you going to negotiate terms? How are you going to say, for example, you're on the start, you're probably going to be the next shareholder in a company. How are you going to ask, how are you going to negotiate for an equity? They're probably second and third years. They don't know, but that's how you're going to get them thinking.
Yeah.
Nobody teaches these things, and these are things, when we come to the forefront in the profession, everybody is lost at sea. So sometimes even like a 2 3 sessions on these practical topics can really make a huge difference, I feel.
Yeah. True. Aditi, these are, thank you for your insight, first of all. And next, I would like to ask if moot courts, as you mentioned, litigation is very important towards gaining first step towards arbitration. So moot courts are a way to get closer to litigation.
Yes.
So do you feel moot courts or something like a WIS moot, which is closer to arbitration, is helpful or are helpful to students, or students should aim for that as well?
Yes. My straight answer, yes. Moot courts are always helpful. Why? Because they will force you to think practically. That is what you need. Because when you are in court, when you are across when you're sitting across for negotiations, trust me on this, all that is used is practicality.
Yeah.
So doing a lot of moods actually gets your brain cells moving and thinking from a very practical perspective of applications of those sections. Otherwise, we are just, reading a section and writing it down, in our papers. But that application has become so important, which moods actually help you to do that. So, will I recommend students to do it? Yes. But then again, my advice would be, don't only think that a whiz moot is something where you're going to learn.
Yeah.
Any moot that comes your way, do it. Because you start even if it's a small one, you start on a playground and then go up. In your fifth year, aim for your Wismoot. Fourth year, aim for your Wismoot. But don't be under the assumption that if I'm not been through a Wismoot competition, I'm any less of a lawyer, or I'm going to be a bad lawyer. No, you're going to be equally a brilliant lawyer.
Yeah. True. So, Aditi, now coming to India's dispute resolution landscape, do you think, or how do you think, a Mediation Act combined with Arbitration Act and now coming ADR will shape India's dispute resolution landscape? What are the major changes or new profound rules and cases we can find, and how will it change the landscape of India?
People are going to start looking at us from a perspective where there is going to be resolving of disputes. Right now, the perception that people have in the West or in the Orient is this, that we are a jurisdiction where things get dragged on for years, right? And we are doing everything in our capacity to change that. Mediation, with that new act coming in, brilliant. ODR coming in, again, brilliant, because we are telling the world that, look, if tech is the way, we are using it even here. So all these three acts combined, your arbitration, domestic, international, where we are pushing ourselves as the next big international arbitration hub. And I know for a fact, of course, we have a bit of infirmities, but I know we will get there. For your heavy duty commercial contracts, because with the amount of investments coming in India, we are seeing that commercial cross border disputes happening, commercial cross border agreements happening. So your arbitration is limited to that, or your international arbitration is limited to that. Your mediation is limited to resolving disputes, even if there are probably say cross-border parties who want to resolve a dispute. We are giving them an idea that look, inherently we are a we are a country which moves towards resolving disputes because we have a structure in place, and then ODR to say that we are tech driven. So combined with all three, I think we are good to go.
So, by your talks, I can assume that India can become a major global ADR hub.
We can.
Or what do we need? What are we lacking yet?
What we are Okay, let's first look at the positives. Can we be? Yes, 100%, because the perception of the world towards India has changed and we are capitalizing. So can we be? Absolutely. Uh, will it take time? Yes. But we are on our way. That is something that I can definitely say. What we need is uh, we need a lot of confidence in the institutions, institutional arbitrations, as we call it, like the MCIA. Indian people are still not, the Indian diaspora is still not used to institutional arbitrations. And we can't blame them because it's fairly new, it's coming in, people are getting exposed to it. Of course, the financial considerations are always there because ad hoc arbitrations are a lot less cheaper. But what we need is a lot of confidence on the institutional arbitrations. We need a lot of consistency. Plus, I think, let's see what the new bill says, the new arbitration bill that is going to come in. So we are looking forward for some changes. But I think primarily and this is my personal opinion, it can be disputed, there can be there can be contradictory views to it, but I just feel that if we need to be the next big international arbitration hub, our arbitration act needs to be a lot more international friendly. And I also feel that we need dedicated arbitration courts. That is something that is absolutely necessary, that we need we need at least 10 judges in every high court just dealing with arbitrations, especially with the amount of international arbitration awards that are coming in. So yes, but we will get there, and I'm very confident that we will.
I hope we do. So, Aditi, one last piece of advice you would like to give for students who are aspiring to become ADR professionals someday?
Start small. Start small. That one step is going to lead you to that bigger step, and the next bigger step, and the next bigger step. Concentrate on your foundations. Nobody, we are still learning. I am still learning. And that sea is as vast as it can be. But don't jump right in it. You're going to be overwhelmed. So start small. The next step, you will be shown the next step. So start with your foundations, as I said, read the Arbitration Act, go on your Contract Act. Make sure that you draft. And again, I'm going to say this, when you make your first draft, when somebody tells you to make the first draft, don't use ChatGPT.
Yeah.
And
That is something, yeah.
don't use ChatGPT. Not because I'm against it. I'm as tech savvy as I can be, but I'll tell you what I am seeing. We were told to draft. We did not have precedents. Then the precedents that we had were all hard copies. So we had to read it, and we then had to, probably memorize it, for a lack of a better word, and then we had to draft. That is the reason why, prayer clause became cemented in our head, or probably a clause in a contract became cemented in our head. So my advice would be, the first draft, please don't. It might be terrible for all I care. Even my drafts today can be terrible. But your first draft, please draft it the way you like it. Ask ChatGPT how I can improve on it later. But please don't do that, because your chat GPT will not make you a brilliant lawyer. And trust me on this, you are going to be interviewing with people who have been in the profession far too long. So everybody can see through as to
Yes,
what have you done and what has chat GPT done.
that is the biggest misconception students have, that
Yes.
we can't see through it.
Yeah, and this is, and see, I'm all for students. I'm all for, because
Yeah, yeah, of
and
course.
I had lovely mentors in my life. So I know for a fact that, we have a brilliant population out there who are going to be, and trust me, I have worked around, so I know for a fact, I think Indian lawyers are some of the best in the world. So I have extreme confidence on the younger generation who are going to be lawyers. I just feel that when you're, in your journey as an ADR professional or even as a lawyer, start small, go back to old school methods, start with, reading your basics.
Yeah,
I said litigation, go there, do that. Draft, first draft on your own, learn how to research. Don't ask ChatGPT, where is this case law?
yeah.
I mean, now I can't even say go and pick up a AIR. I don't think anybody does that. But
No.
please go to a SEC, read the judgments. And then once you have a hang of it, use ChatGPT to assist you. You are the lawyer, not the ChatGPT. So yeah, and
Yes.
then you will reach there. You will reach there, but do litigation. That's my fundamental advice. Do litigation.
I hope students hear you and implement it, really. So, thank you so much, Aditi, for joining us. Today's discussion showed how mediation, arbitration, and ODR are creating such new pathways for law students. So, now we know ADR is no longer just an alternative, it's the future of dispute resolution.
Correct.
So, students, please explore it, experiment with it, and
Please,
shape your journey in law with
please.
ADR. So,
Yes, 100%. And it's going to keep growing.
yeah, of course.
Yeah, it's going to keep growing, and I mean, there's too much to do.
Okay, I have one question, Aditi. Someone has asked, how can ADR be used in media industry?
What particularly do they mean by media industry? Any specific? See, media industry is your media laws. If so, your media laws, if that is what they are talking about, right? So when I say your media industry, as I said, that it's a very broad,
Not,
very,
yes.
very broad question. So see, it's like any other dispute. It's just about any other dispute, until and unless you want an urgent interim injunction, which you can also take in an arbitration. But more often than not, when it comes to this, you go to a court for immediate interim injunction for an IPR infringement or something of that sort. Otherwise, see, your media industry dispute is again it's a dispute. It's just a different, it's a different branch of it. It's like saying that, oh, there is a real estate dispute, there is a contract dispute, there's a media industry dispute. There is no difference as such. So can it be resolved through arbitration? Of course it can. And are the procedures same? Of course they are. So there is no difference as such, when I just term it as a media industry dispute.
Media
Yeah,
industry,
yeah.
yes. Thank you, Aditi. Thank you for joining us. Hopefully,
Pleasure.
we'll see you
Very mine.
again
Yes,
sometime in campus also.
happy to, happy to.
Thank you so much for joining.
Thank you so much, Pallavi. Pleasure.
Bye.